Take 1 second. Good to go.
Thank you. Welcome to our electronic special meeting tonight, December 22nd, 2020. We are holding a public meeting today. This meeting is broadcast on the YouTube link, live link at washingtoncity.org/meetings. We welcome any of you and all of you who are tuning in on virtual. We appreciate your support in the city. Move on to item 1, approval of the agenda.
Mayor, I'll make a motion we approve the agenda for 12/22/2020 special council meeting.
I'll second.
Thank you. I have a motion and a second. All in favor?
Aye.
Item 2, development agreements, continuation of a consideration to approve a development agreement for the Long Valley Trails PCD development located 3000 East, 1600 South, Long Valley Road, applicant Brennan Family Holdings, LLC. Yeah. Oh, there you are. Hello, gentlemen. Whenever you want to kick it off, Mike. You want to kick it off, Michael?
I would probably turn to Jeremy. I don't see that well exactly who's there, but I believe we had provided a red line for the council to review. We also exchanged that with Developers Council. I see AJ looking good in a sporting a red tie. And
Christmas, we're here almost, right?
there we go.
Thanks, Mike.
But we provided AJ on behalf of the developer with that red line as well. We had just one revision that we made as a result of that discussion. I think I pointed that out to Jeremy as well, and then provided a clean version of the document with that revision incorporated. So I think my representation would be, I believe it represents a document that's acceptable to the developer, and at least from my standpoint, acceptable as representing the city.
So you said you didn't know what to say, and then you said it perfectly. So I would mention the only change was in section 12. We just made the language consistent with the other references in the agreement to the vested laws and the future laws. So that was the only.
You're suggesting there's a change beyond what we have in the packet here, or is there?
So there was one little change from the one that went out Saturday. So it came in a subsequent email yesterday.
But the one, which version was put in the packet then?
The red line version.
Well, I know that, but does it include this change or not?
It did not include the last change.
Did the one from your email?
The one from the second email did, that was sent out yesterday.
So I could lead you through that revision.
Walk through.
And it is it's really straightforward. We had throughout the document, as you might have gathered as you looked at it, we'd had a couple of phrases that were used, and we kind of tried to figure out how not to simply repeat the same phrases over and over, but it worked. And so and that really relates to uses of the terms cities vested laws and cities future laws, both of which are defined in the document. But as we got down to section 12 of the document, take you to what is page 14. There was I think the red line that you were provided, what apparently was in your packet, said in that first line, to the extent permissible under applicable state law and city ordinance or city ordinances, the city agrees that, and then goes on. And the change that we had made was to utilize the same language we've used throughout the document when we're talking really about the city's ordinances or city's laws. And that is, so then we struck the word ordinances and then put in the words city's vested laws, or if applicable pursuant to section 5.3, the city's future laws. Just simply makes that that language consistent with what had been used in other portions of the agreement.
Any comments on that? AJ, how do you feel about that?
Mayor, members of the city council, thank you. Agreed with that change. I think it, to Mr. Day's point, it's really just a matter of a consistency change. And so we were in support of that and requested that change.
Thank you. Any additional comments or questions from council to the
Mayor,
developer?
I do have one question if I could. This is probably for Mr. Raines. I've talked to Mike Shaw about this, Jim. In section 10, it's been there all along. It's just a matter of clarity. Understanding in my mind, I guess. The last paragraph talks about the UDOT and the fact that drainage, would be, there's some issues there that have to be worked out with UDOT. And it just indicates that, let's see, actually, it indicates that Brandon would not, pay anything to rectify the situation there. Does that ring a bell to you?
The intent, I'll take that down. What it says is that we're going to resolve the existing drainage flows, the natural flows that come out of Long Valley. We're going to handle all the post-development flows. And we worked with the property owners to get easements to pipe it through. And so we're not impounding water on an unapproved dam that's there, an old irrigation pond. We're going to pipe that water all the way to the river. What that is saying is that whatever UDOT has contributed to that, we're not taking UDOT's responsibility.
Because it just says Brandon does not agree to incur any expenses, and I just want to make sure that the city isn't incurring any expenses.
We haven't evaluated UDOT's whole drainage thing and how it impacts that. We'll build what we need and what the city needs. But UDOT just dumped water under these private.
As long as I just want to make sure it's understood, nothing's going to come back to the city to have to participate.
No, it's a UDOT.
Acquire land or anything like that.
We're leaving UDOT's problem.
Okay, very good. Thank you. Appreciate it. And that's really the only question I have.
So I had a question unless there's something else on that. Okay. On 11.9, during our last discussion, we talked about saying a minimum 4-acre park in that paragraph under the community parks, but it just says Central Park. Wasn't that a condition that we had on the language?
Back to my notes.
I recall that as
Was
being.
I just don't, was it that size though? Was it?
Yeah.
Just a
and
minimum
the
4-acre.
conversation also was that there would be at least that amenity, but that the city and the developer would basically decide what the city would be willing to take and maintain.
And
I do remember
it
that
says that at the
point.
end. It says the city reserves the right to reject the dedication of any of these parks if it is determined that such park does not meet city standards.
Yeah, it's our intent to make that entire Central Park.
Yeah, I just want
a
the
city park.
I understand it's your intent. I just want the language in there so that it's everyone's intent long term of somewhere that you will include a minimum 4-acre park.
It's in the development. It's not in it's in the PCD plan. We made that change, remember? So we added that minimum 4-acre thing. I don't know. This has gone through so many iterations. I'm not sure.
Well, that's
where
why
we got
I'm trying to
here
remember
tonight.
what we talked about in the PCD.
It's in my notes. It's a 4-acre park.
Do you want me?
to
I got the
city
PCD
standards.
plan. I can read what that says.
We wanted it in.
Have it marked, check marked off.
No, I know it's in the PCD. I'm saying in the development agreement, we made it a condition on the last one we were looking at approving to have the language of saying in this that it'll be that you'll provide a 4-acre park.
So Councilman, on 11.9, that first sentence, I'm just trying to read that and wonder if that satisfies it doesn't specify 4 acres. It says the project will include a variety of private, public, community parks as described and depicted in the PCD, including a large central park described and depicted in the PCD plan. Does that reference the 4 acres or?
It just says Central Park, but that whole valley is
That's
the
the whole
Central
strip.
Park.
Yeah. I see what you're saying. I mean, it wouldn't really be a public park unless it met our standard.
Yeah.
Well,
just
remember that
found it
the development agreement is part and parcel to the PCD plan, and the PCD plan is part and parcel to the development agreement. So let me read the change we made in the PCD plan and see if you're comfortable. I'm not opposed to making changes in the
No,
development.
let's see if
agreement.
that works.
It says the general park providing trail access to residential neighborhoods, main community center, and neighborhood amenity centers. The park will be the center focus of the entire community and may include all the items listed above, as well as an 18-hole disc golf course, trail overlooks, active recreation areas, which may include grass ball fields, which can accommodate organized sports. Areas for parking and other access will be provided. The Central Park will include a minimum 4 acres that will meet the requirements and standards of a public park.
And what version did that get into?
That's the final version, section 2, page 4 and 5.
And Jim, if I may, the PCD plan, what Jim just read from, is actually attached as an exhibit to the development agreement. It's Exhibit C, and it's incorporated by reference into the development agreement itself. So in effect, it becomes one and the same together with the development agreement.
It does say depicted in the PCD plan, so as long as it's in there, it should cover it.
We did address it. I just
want to make sure. I know we went back and forth. I just didn't. But we did talk about having the language in there last time, so that's the one thing that I noticed reading it, that it wasn't in there.
We're comfortable with the language in PCD. If you want to restate it here, I'm okay with that. Whatever you're more comfortable with.
I'm comfortable with it if you guys are. I mean,
Well, I just have a question for Jim. Just I was, as I read through the latest development agreement, I was looking at some of the highlighted red items that precipitated the meeting tonight. And some of those words are, outsourcing. That addresses some of the past problems that we've had, and arbitration, mediation. And my real question is, my understanding that in mediation, when you hire an expert to mediate any problems, that they are not binding. Not that I anticipate any problems. I think it will be smooth sailing, but I just was wondering why, if that is the case, what the fallback is on any unresolved issues, which again, I don't think we're going to have any. And this is more for my own information rather than a council question.
I'll let AJ and Mike address that, because that's the legal back and forth that's going on them. The way AJ explained it to me was that by taking all that out, the only recourse if there was a dispute was to go to court. And what we wanted to do is have another route or another avenue to pursue if there ever was a dispute, so we're not just forced to go to court.
Right.
AJ,
Can
is
we
that
do
correct?
that? Can we have Mike Day respond to that? That's one of my questions as well. And I understand that there was quite a bit of back and forth. You maybe just kind of update us on what your thinking was and how this moved along and how, because there's provisions for mediation, but also arbitration. Is there? And I got lost in some of the legal language there as well.
Okay, let me summarize, and then AJ can clarify or confirm that we're on the same page. The document that we started with basically had both a mandatory mediation for, in essence, all disputes, with an mandatory arbitration for certain types of disputes. And as we reviewed that, we could see the value, particularly of the mediation. I mean, if any of you have been involved in litigation, once a matter gets to that point, parties have dug their heels in generally pretty deeply. This is a project, because of the size of it, that I'm assuming that everyone expects it to take quite a number of years actually to get to build out and be completed. And so there's going to be a long-term relationship between the city and the developer. Oftentimes, when that's the case, the idea of mediating and allowing the parties an opportunity to come to agreement is an attractive one, because it helps to preserve that relationship and allow the parties to come up with solutions. As was mentioned, mediation is not binding. This would not be binding. And additionally, I think we've got in all provisions that it would also not be admissible, anything that occurs during the course of the mediation and in any future proceedings. So as far as mediation goes, the door is wide open for all disputes to go that route if the parties can't come to agreement on their own. Then it pivots a little bit. If we're unable to resolve by mediation in a non-binding setting, then originally the document had a mandatory arbitration for certain disputes. And what we've done is made that permissible rather than mandatory. And we've said, if the parties come to agreement, they can certainly go to arbitration. Now, some people would say, well, you can always agree, right? You can always reach agreement that we're going to arbitrate this. Why do we need that in the document? But there was some value, I think, in two respects. One is, of course, to remind the parties that that option is there and available. The second is that within the document itself, it provides that procedure. We wouldn't have to revisit that in the event that the parties determine that they do want to arbitrate a dispute. And so I see the value. Again, neither party has a mandatory obligation to arbitrate. That's going to be by mutual agreement. And again, I think there's some real value in providing the parties with the opportunity to come to resolution short of litigation, particularly in the mediation setting. AJ, your thoughts?
Yeah, Mr. Day, I agree completely. I think that that's well stated. And to the point that Jim made initially, this just provides some process so that we don't get stuck defaulting into a litigation scenario under the state code.
So then can I just clarification on there? So first question is, sorry, Councilman, I know this was, you started with this. I shouldn't.
No, you go right ahead.
Oh, sorry, thank you. So is the arbitration and the mediation consistent throughout all aspects, or does it apply to only certain sections of the contract?
So the mediation, I believe, is in essence almost any dispute that would arise between the parties. First would go a mediation route. Arbitration is only applicable to the extent that the parties want it to be applicable and agree to have it be applicable. So that there's nothing that's mandatory about the arbitration. Again, it's based on mutual agreement of the parties.
Okay.
And when you do arbitrate, isn't the whole purpose is to bring in technical experts to kind of clarify and to find resolution?
Well, arbitration, and people have differing opinions. Number one, it's binding. It's a binding process wherein you are authorizing that arbitrator to make a final determination that will bind the parties. Another point in it is that oftentimes it allows disputes to be resolved more quickly. Any of you who have experienced the joys of litigation know how that process clicks along at a pretty slow rate. There are periods within the litigation through the rules of civil procedure that allow for certain timeframes, and in some instances those are very generous. I think the disputes that would arise under any type of a development scenario would probably, in most instances, benefit from a quicker process, and arbitration does lend itself to that. The other differences would be, one, when we litigate, we don't pay a judge for his time on a case, at least not directly. But in arbitration, it would be the obligation of parties to compensate whoever they selected as the arbitrator. It can be a little less formal than litigation. Some of that depends on the parameters of the arbitration agreement that is utilized. Now, we don't try to spell all of that out. We'd allow the parties to kind of determine what are the procedures that they find attractive and applicable. And it would certainly be possible that in one, if you were arbitrating two different matters, that you might want the parameters to be different as between the two. So again, it provides the parties with some flexibility.
And
I certainly don't want to imply that I think there's going to be problems. I have a very high level of confidence, and I've always appreciated the professionalism, and I don't anticipate problems, but it's good to have this up front so that we don't, I guess. Anyway, thank you for your information.
And if I may just add just 2 quick points about it too, just to what Mr.
Before
Davis
you
said.
go on there, Ken, I'm going to just keep on that
Yeah.
same point and just ask Mike Day to just, so when you're talking about the arbitration agreement, it would be incumbent upon the city at that point, during the arbitration agreement phase of entering into arbitration, to make sure that they were specifically making sure that that this contract was taken into account and city and state law was taken into account, or help me understand how much of that is automatically taken into arbitration.
You know, in submitting the matter to arbitration, obviously, first of all, the parties are going to enter into agreement that's how they're going to resolve the dispute if it gets to that point. They would enter into an arbitration agreement with the arbitrator that they ultimately select. That arbitrator presumably would help the parties craft their agreement. The parties would certainly have an active part in determining things like how long should our discovery period last, and what should we be permitted to do in the course of discovery. For example, do we put a limitation on the number of depositions that we hold? Do we put a limitation on interrogatories or the request for production of documents that can be propounded between the parties, and set up some of those timeframes, some of those ground rules. The other, I guess, in responding to the remainder of your inquiry, the parties also are going to have a hand in selecting who that arbitrator is. And the arbitrator, as a general rule, will have a good idea of what he or she wants by way of documents. The parties are going to brief the arbitrator, generally file some type of an arbitration brief wherein they identify what the dispute is, identify their positions, and provide to the arbitrator the documents that they think are operable. So it is in many respects, a mini litigation, with the ability again to expedite things. I mean, you're hiring an arbitrator who presumably has expertise in the area of the dispute covers, and whereas with a judge, again, I don't know if AJ litigates. I don't do a lot of litigation, but we find generally in the 5th District Court, when you get to the point that you are indicating that you're ready for trial, the court then looks at its calendar, and depending on the amount of time that you need, you could end up from anywhere between 4 months to 8 months, maybe, of lead time before the court's calendar provides open dates. And with an arbitrator, again, that's a period of time that we would assume you avoid having to wait that kind of time frame to get to trial, where the parties really is dead time. Parties are kind of sitting on their hands, preparing in some respects. But if you have a trial date that's 8 months away, I don't know of very many attorneys who start preparing at that point. I mean, you lose so much continuity if you prepare too far in advance, and so you generally you do some cramming because most of your groundwork has been done before you ever get that date.
So, but the arbitration decision is still taking into account city, state, federal law, and the contract and the what's agreed on in the contract. correct?
Absolutely. That would, I mean, that would be,
It doesn't
that
modify.
would be, those would be the guidelines that the arbitrator would use, just as the court would use those same guidelines for determining the rights and the interests of the parties.
Thank you.
And just one clarification that I wanted to make too was we specifically provided for in that arbitration process provision that the developer is the one responsible for paying the fees of the chosen arbitrator.
That's good. Thank you.
And it's a great thing to have the developer's attorney put that on the record. That's a kind piece of integrity, I think.
Thank you, gentlemen. Any additional questions? I would entertain a motion.
I move that we, go ahead.
Go ahead, Councilman. I was just waiting for someone else.
Motion that we approve the agreement that has been modified and for the discussion that we've had. I'd like to, along with that, express my appreciation to Mr. Day and Mr. Pepper for working together and coming to terms with what will work for both parties. So with that, that's a motion to approve.
Well said. I'll be happy to second that motion.
All right, thank you. We'll do a roll.
Mayor, just one quick question for the council. So we made several different motions, and it just suddenly occurs to me that I didn't really go back through this document to see that each one of those were accounted for in the final draft here. I guess, are we completely satisfied with the work that we did previous week is contained in the document here? We covered the park portion.
Yeah, we remember we took 150% density leeway
Saw that was in there.
down to 115.
Yeah.
There was the word partially we removed. We put
The
trail
trail.
language in. So all those substantive
park, we
changes
addressed
got
that.
made. Those weren't ever in dispute. The dispute was between the attorneys. So the things that we talked about are all in
It
there.
just suddenly occurred to me that I kind of made an assumption there, and
They
I
are,
didn't,
they're
I didn't
in there.
really tick down through that whole list. So
The changes
leaning on
these
my-
guys have made have been based on the things you've discussed, but legal language, not in the deal that we did with the city is the deal. We haven't changed any of that.
there was something in there about the rock fall as well. That made it into the contract.
Yeah.
Thank you. Appreciate you entertaining that question.
I have a motion. Did you want-
Staley, aye.
Did I have a second?
Oh, yes.
Okay,
Give a second.
okay, thank you. Okay,
Staley, aye.
thank you.
Ward, aye.
IBI.
Goats, aye.
Bundy, aye.
That is approved. And Mr. Pepper, Mr. Day, thank you so much for your time, gentlemen. Hope you have a Merry Christmas.
Bob Brennan just really wanted me to extend
you.
his and
Thank
I's
you, everyone.
his and I's great appreciation for this process, and you're willing to come in this close to a holiday and address these issues. We've always viewed Washington City as a partner, and we truly believe under this situation we've been treated as a partner. So again, both Bob and I want to really express that it means a lot to us the way this was handled, and thank you again.
Yeah,
So I guess I appreciate that. My only question is what are we doing next Tuesday?
Well, we'll see. I'll come up with it. I'll buy lunch.
Don't give him an opportunity to bring in a
Applebee's is good.
project.
I think Friday would be a good day for a special meeting, I think.
Yeah, we
With
do
the
have a need to
family.
go to a closed session to discuss character or professional competence of an individual.
Thank you.
Thank you. Merry Christmas to you too.
Thank you.
Go ahead, make the motion then that we adjourn this portion of the meeting and move into closed session to discuss the character or professional competence of an individual.
All right.
Second.
Thanks. Thank you. All in favor?
Aye.
Aye.
No, well, we don't have the background. Yeah, yeah. Really? Who was it? Yeah.
This stack is bigger than this stack. I think you must win. You provided. No,